And tonight we're dealing with the last of the series in Abolition, the unwritten Constitution, which of course is a British speciality. They've been building it for hundreds of years, and of course it works very well for the ruling class. It's not to say that the ruling class can't do a job with the written constitution, as we can see in the US and other parts as well. You know, everything can work in its own way around. But the British one is particularly obscure, of course, and it means you can go around pulling rabbits out of hats very easily in case of need. So I shall leave this one to Mike. I'm looking forward to it myself. Thanks, Mike.
Okay, thanks, Matthew. Dina asked me to do this after I wrote an article called "Spin, Traps and Rights" in the Weekly Worker on January 27th, which was directed against Dominic Raab's human rights proposals and against the response of much of the left, which was to, quote, defend the Human Rights Act 1998. And my argument about Raab's proposals is essentially, having read pretty carefully Raab's proposals, that it's in substance 90% spin, and with roughly 10% operative stuff, and the 10% operative stuff is just to make life easier for ministers and more difficult for people who want to challenge the decisions of ministers in courts. But the spin is important. It's all about British nationalism and so on, and it's also designed to put the left into the position of choosing either to accept the Tory party's turn to English nationalist populism, in this case English nationalist right populism directed against the Human Rights Act on the basis of unreasonable, inconvenient, etc., 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 or alternatively to stand up and, like the Remainers, be committed to the defense of elitism in the form of the Human Rights Act and judicial review. And in fact, actually, in defending the Human Rights Act, we have the additional element beyond that we're defending in general judicial review and elitism, that we're defending the right of the courts to strike down legislation which is inconvenient to legislation on the law of torts, which is inconvenient to insurance companies, a case which the Supreme Court said they can do it, but they chose not to do it in the case at hand because it was within the margin of appreciation for the Scots government to change the law of torts in ways disadvantageous to the insurance companies. But nonetheless, they were prepared to say that that was a violation, prima facie violation of the insurance companies' rights. Or celebrated one more than 10 years ago, the legislation on rape prosecutions was struck down on the basis that it violated the defence's human right to run arguments that she's a slag and therefore ought not to be believed because she's a bad sexual character. This very considerable ambiguity about judicial review, which is not just about judicial review, is elitist in itself, but is also about judicial review, is actually most of the time directed against the things which we might want to be able to do. And usually when it's directed against government, we get grand statements of how it's the law protects the citizen, and then large caveats. So, for example, in the two Belmarsh cases, the first Belmarsh case says you may not detain without trial British citizens and aliens. Aliens, because that's discriminatory, but it would be lawful to detain without trial British citizens and aliens. In the second Belmarsh case, You may not use evidence obtained by torture in order to justify detaining people without trial, but it's up to the defense to show that the evidence was obtained by torture, and the fact that it was obtained in Uzbekistan is not a reason for a court to believe that it was obtained by torture. So Raab's stuff then inviting opponents to enter into a trap. Now, of course, the reality is that this is now that this set of political maneuvers has now been superseded by the Iraq War. We no longer have human rights stuff. Instead, we have war controls. The Ukraine war. Instead, we have war controls on the media and suggestions that we're going to have war controls on universities, etc., etc., etc. I suggested in the Raab article that we should, quote, we should counterpose to Raab's proposals an actual modern Bill of Rights, one which, like the Bill of Rights 1689, began by declaring illegal the main lines of the policy of recent governments. In this case, what would be at issue would be a Bill of Rights to restore democratic rights, to restore the right to self-government, both in the localities in the form of local councils and in sectoral organizations by demanagerializing universities, schools, and so on, to restore trial by jury, to replace the press freedom which permits speech, only speech approved by the advertising funded media, with real freedom of speech and communication, to declare the illegality of the kettling decisions, which said not only that the police can lawfully detain you by without giving any notice whatever by enclosing a demonstration, but that this isn't even an arrest when they do so. Stunningly, stunning violation of at least 500 years of law. Reasserting the duty of universal military training and service and the right to bear arms, and so on. Proposing a real modern Bill of Rights, I suggested, would be a better way to expose the real politics of Raab's fraudulent scheme than the delusive, quote, realism, unquote, of defending the European Convention and the Human Rights Act. There's a larger issue which lies behind the Raab and the question, what mean by real Bill of Rights or whatever. In September, October last, I wrote a 5-part series on, quote, ancient constitutions, which was driven by the fact that people are arguing that the United States Constitution adopted in 1789 is archaic and is a terribly old constitution and creaking and needs to be updated or replaced. And conversely, that the right-wing Christians and so on and so forth argue for what they call is the original meaning of the US Constitution as something which overrides modern interpretations of the Constitution. And of course, the original meaning of the US Constitution is included the protection of slavery and the absence of the right of women to vote, etc., etc., etc. Conversely, the British Constitution is celebrated as a 1,000-year constitution, was celebrated as a 1,000-year constitution by Tony Blair, and in fact before and immediately after him by John Major. Though in reality, most of the modern structure of the British Constitution is 20th century. And in 2004, when Blair proposed to abolish the office of Lord Chancellor and create in its place a Minister of Justice, there was an enormous outcry from the Bar and indeed also from the Conservative Party on the basis that office of Lord Chancellor was 1400 years old, going back to somebody, I'm not quite sure who the hell thinks that there was a Chancellor of the Kingdom of Kent in the early 600s, and that it would be terrible vandalism to abolish the office of the Lord Chancellor. And it's important protection for the independence of the judiciary to have a senior barrister as Lord Chancellor, who is charged with protecting the independence of the judiciary. This, in reality, this last one, the idea that Lord Chancellor is protecting the independence of the judiciary, was a tradition invented in 1945 against the incoming Labour government, and never applied to Conservative governments until Havers in 1987, because Quintin Hogg, as Lord Hailsham, who was Maggie Thatcher's first Lord Chancellor, and Ted Heath's Chancellor before that, was a unambiguously political Chancellor and acted with overt and explicit political action, and indeed all Conservative Chancellors before had done. So we get this appeals to the enormously long duration of the Constitution. In my opinion, actually, both of these arguments are totally unsound. The gridlock in the US Constitution only applies to domestic politics and not to the imperial policy of the United States of America. And it's only gridlock against the initiatives of the American center-left, not against initiatives taken by the right. It's in that sense, it's sort of like the liberum veto, the free right of veto of the aristocracy, which existed in the Polish-Lithuanian Commonwealth, though the right don't veto the passing of taxes to pay for massive increases in arms expenditure. So in that sense, unlike Poland. Conversely, as I said, the ancient British Constitution is nothing like as ancient as on the face of it appears. Okay, step back. What is a constitution? Basic point, a constitution is the general body of rules or institutions by which a polity or organization is governed. We can talk perfectly sensibly about the constitution of a golf club or the constitution of a left-wing political party, or of the Labour Party, which I don't count as a left-wing political party, as well as of the constitution of the state. The British Constitution is famously or infamously unwritten. This does not, in fact, mean that the British Constitution is wholly not in writing. Large parts of the Constitution are, in fact, in statutes of one sort and another passed by Parliament. There's even a little bit of Magna Carta 1215, which was 1225, which was in 1215 a peace treaty between the king and his baronial opponents, and then King John having died, the guardians of Henry III reissued it in order to win political support, and it went on being reissued. And the version which is in the statute books is the 1225 version, most of which is repealed, but a few bits of which are still there. The Bill of Rights 1689 similarly is in the statute book, and indeed, again, quite a lot of it's repealed, but insignificant parts of it are still there. So, for example, the prohibition, the denunciation of James VII and II for interfering with the government of the City of London has the effect that the city, that is to say the financial district, remains in existence as a separate local government institution, complete with, in essence, its late 17th century constitution with property qualification on the vote and votes in proportion to property holdings and complicated structures of this sort. So there's stuff in there which is in writing, and the representation of the People Acts are part of the Constitution. The Political Parties Act is a new element of the Constitution, which the established parties introduced in order to protect themselves against rivals by imposing a requirement of registration of political parties. On the other hand, it's not all in one place. US Constitution or the Constitution of France or Germany or whatever, you can go and, in principle, you can go and look up the Constitution and say, hey, it says in the Constitution X. Of course, understanding what it means when it says in the Constitution X is a slightly different question. As Matthew said, the characteristic of the uncodified character of the English Constitution is that it's a lot easier to pull rabbits out of hats. I referred to the scandal which was made about the abolition of the office of Lord Chancellor, which ended up with the Constitutional Reform Act leaving the Lord Chancellor in place, but moving the office from the House of Lords to the House of Commons as a front bench justice spokesman. Again, the judges were accused by conservative authors of violating the Constitution in the two Miller cases, first on whether Brexit had to be done by an Act of Parliament, and the second on whether Boris Johnson could use the Queen to prorogue Parliament, obsolete, not obsolete, but an obscure prerogative which allows the Queen to, in effect, adjourn. It's not quite the same as adjournment technically, but to suspend the meetings of Parliament. The absence of a codification means that there's no cut-off. John Finnis, who is a retired Don at the university where I work, polemicized against the Miller cases on the basis that the judiciary were here interfering with an inseparable prerogative of the Crown. That is, that it's fundamental to the nature of monarchy that the Crown should have an unfettered right to conduct foreign policy and should not be controlled in affixing the signature to treaties or removing the signature, signing or denouncing treaties. That the Crown has to do that. As the argument for the unfettered right of the Crown to conduct foreign policy as an inseparable prerogative of the Crown, which is not taken away by subsequent legislation, is essentially the line that there are inseparable prerogatives of the Crown, which was adopted by the Court of King's Bench in the case of Godden and Hales in 1686, to say that King James VII and II had the inseparable prerogative of dispensing with the law, that is to say, of saying that an individual could be, in this case, Hales could be an army officer in spite of legislation against Catholics being army officers. And there were a whole range of issues which were posed by Godden and Hales. The particular decision in Godden and Hales that the power to dispense was an inseparable prerogative of the Crown is struck down by a provision of the Bill of Rights 1689, which is in fact still in force. But the underlying argument that there are inseparable prerogatives of the Crown, which you can't get rid of, remains available in spite of the Revolution of 1689, and Finnis digs it up to go along with arguments from the natural law theory of monarchy on the basis of Thomas Aquinas writing in the Middle Ages. This connection has a history, and back to when we actually attempted to have a republic, which was in the 1650s, and it failed. And Alan Cromarty, who wrote a biography of Sir Matthew Hale, who was lawyer in the 1650s and judge in the 1660s, starts with the statement that the republic was a failure because the common law survived. What's going on here is that there was debate about whether to codify the law or not. And Hale wormed himself, in spite of actually being a supporter of the monarchy, managed to get himself into the center of the Commonwealth's Law Reform Committee and run it into the ground by endless delays and discussions and so on and so forth, as a result of which the Commonwealth never adopted a code. The Republic was a failure because common law survived, the point being that monarchism and the prerogative rights of the crown are so deeply embedded in the common law that without codification, you will never get rid of the underlying commitment to monarchism without drawing a line, a clear and unambiguous line. You will never get rid of the underlying monarchism. We can put it another way in terms of the 1650s. Radical law reform, radical simplification of English law in the 1650s, of the sort which was in fact undertaken at the same period in the New England colonies, Massachusetts and elsewhere, would almost certainly have won mass support for the Commonwealth, but been uncomfortable and ambiguous for the landowning class. Not Hale, but another monarchist lawyer, Heneage Finch. One of the issues raised in the 1650s was whether to have registration of land titles. And when that issue was raised again in the 1670s, Heneage Finch said to the landlord class, the problem is if you allow this registration to go ahead, it will be impossible for you to borrow more money on your estates than the value of the estates, and that saw it off. So the point is that codification and republicanism and codification march hand in hand. That it's the question of having a codified constitution. The celebrated English uncodified constitution is a hat out of which endless rabbits can be pulled at one stage or another. It's a regime of judicial power, and sometimes the judges do things which are nice from the point of view of left-wingers, but an awful lot of the time they do things which are not nice, either from the point of view of left-wingers or from the point of view of the working class, and in particular the anti-trade union legislation is in origins at root entirely judicial creation, judicial invention. Equally, the British taxpayer pays 17 billion a year for housing benefit and related benefits paid to people who are paying rent of one sort and another, essentially because the Court of Appeal eviscerated the Rent Acts, and by eviscerating the Rent Acts made it possible for the Thatcher administration to knock them down on the basis that they now no longer applied to anybody except council tenants, and council tenants were a minority. So we need codification of the Constitution. We need codification of the law in general to mark a cutoff point. We need to think about doing it in terms of not the protection of the existing Constitution and not loyalty to the existing Constitution, but thinking about principles for the future. And the principles for the future are, I would argue, it has to be principles of self-government. Self-government in the localities, but also self-government in the center. Self-government in the center implies significant changes in the way in which we work the relationship between elections and central government and so on. It's not wholly possible to abolish unwritten constitutional rules. The reason why it's not wholly possible to abolish unwritten constitutional rules is that there is no such thing as an ordinary natural meaning of words. Words have meanings depending on the contexts in which they're used and on the conventions within which they're used. To take a single example of a piece of case law in recent Stevens Walbrook, the question was whether the parish church, whether the vicar and one of the church wardens could get a 20-ton Henry Moore statue put in the place of the altar with a flat top. It was opposed on the grounds that this wasn't a, quote, communion table within the canons of the Church of England of 1603. The diocesan court said, no, this is not a table, because if we look at why the canons of 1603 were introduced, the consequence is that table meant something which can be moved around the church, and this thing clearly can't, and not an altar. The Court for Ecclesiastical Causes Reserved, on the other hand, said table, the ordinary natural meaning of the word table, is an elevated surface you can put things down on. Okay, so the chair on which I'm sitting is a table, and the desk on which my computer stands, that's a bit more plausibly a table. The bookshelf behind me or to my left is a table. The windowsill in front of me is a table. The point is, what counts as the ordinary natural meaning of even a really simple word like table? The meaning can be profoundly different. This is reflected in the United States. The Congress, under the Constitution of the United States, has the power to declare war. The president does not have the power to declare war. The president does not, in theory, have the power to start wars without the consent of Congress. In Korea, however, President Truman said, well, no, I'm not really starting a war. I'm just supplying peacekeeping troops to the United Nations. And therefore, I don't need congressional approval. And on the basis of that precedent, the imperial presidency has ever since argued that committing troops abroad, engaging in military actions of one sort and another, doesn't amount to war, isn't necessarily war. So in particular relation to Vietnam, this was never, as far as the US presidency is concerned, a war. Congress passed, indeed, a resolution called the War Powers Resolution, which was intended to say, no, you still have to get the Congress to come and approve. But the presidency has consistently taken the view that the War Powers Resolution is unconstitutional. And the Supreme Court is not willing to hear this because there is nobody who has a direct interest for there to be a cause or controversy. So that in reality, it's a convention, it's a custom of the US Constitution that the president can start wars overseas in spite of the explicit prohibition in the written Constitution. The other side which goes along with this point is there are quite a lot of rules which are in fact rules about the distribution of political power, which are not in constitutional law textbooks. If you were to go and look at the British Constitution, a very short introduction, or various others, you would not find them. Charity law, for example, defines what sorts of operations can be tax-free, prima facie, poverty charities, education charities, the advancement of religion. They've had big arguments about whether Buddhism or Scientology amount to religions for this purpose. Not politics, but on the other hand, the promotion of NATO is a charitable object. Anglo-South African friendship during the apartheid period was a charitable object. I'm not clear whether, I have a feeling that, no, I'm going to leave the question of Israel and Anglo-Israeli friendship on one side. Charity law, therefore, is part of the constitutional rules. There's a whole things which used to be constitutional rules but have been got rid of. Slavery was abolished in England, English law for people in England, in Somerset and Stewart, but the basis of the decision in Somerset and Stewart is actually that it's unconstitutional for the courts to invent new property rights. And that was a ruling which had already been applied in a year previously in relation to whether there's copyright at common law. The rule against perpetuities was a constitutional rule intended to prevent the creation of closed family dynasties, oligarchic dynasties. So it was abolished in the United States for some reason. Presumably they thought there were never going to be any oligarchic dynasties in the United States. And then as a result of being abolished in the United States, abolished here. Conversely, copyright was invented in the Statute of Anne in 1711 in order to cause an oligopoly, a press oligopoly. The press oligopoly that was created in order to facilitate better control over the press and media than had been possible since the abolition of the censorship in 1696. So copyright and the press oligopolies and the constitutional right of the press barons to decide who should be the leader of the Labour Party as a particular example, these are parts of the structure of the Constitution. Single member constituencies. This is a method of adopted at the time when the franchise was being extended, because there are a whole load of things which were done reducing the powers of local government, increasing the right of the Home Secretary to intervene in local police forces, bringing the militia under the control of the direct control of the War Office outside of wartime, etc., etc., etc. There's a whole load of things which were done in parallel with the extension of the franchise in the later 19th century, so that now that we were letting the unwashed masses or semi-washed masses at that stage, because it wasn't quite the unwashed masses, in to vote, nonetheless, they shouldn't be having so much political power as they would have had if the powers of local government had been left as they were. And we've seen ever since every step increasing steps to take away the powers of local government and so on and so forth. So there is an unwritten constitution in the sense of a concealed political order, which lies behind the stuff which is taught as the unwritten constitution in the sense of the customary order that's taught in constitutional law textbooks. We can and should abolish this unwritten constitution. We can't abolish altogether judicial power and the interpretation of constitutional rules. We can't abolish altogether the fact that constitutional rules include customs and as well as laws. None of that's possible, but we can radically improve the transparency of the constitutional order, and we can campaign for a democratic constitution, a constitution founded on self-government of everyone, not on minority rule. And that's all I'm going to say.
Right, comrades, I think we have a few folks to speak. Fortunately, want to manage to promote them all. And thanks for that very interesting contribution. Okay, so shall we start with Tony? If you can get yourself right way up.
How about doing somebody while he gets himself right way up?
He almost is. There's a picture of his window.
He takes Steve Freeman. He's eager to go. I'll go second.
Okay, that's only better because Tony can see what's coming up then.
That's exactly fine.
That's why you wanted to get me go first, so you could attack
me,
Tony.
You're impugning my bona fides.
No, it wasn't. It just gets you upside down, and that's fair enough.
Yeah.
Mike, hi, Mike. An excellent talk, detailed and wide-reaching. It's really good. I think I would start by saying I don't think the left generally is that interested in constitutions. Maybe they think it's just words. And as you say, words have got meanings, by the way, in the way that you explained, different meanings, of course. Trade unionists, active trade unionists are, because they're interested, as you pointed out, in the trade union rule book. They understand that that is actually about power and how unions actually operate. But we have to remember that constitutions embody class relations. They are as if these relations were frozen in time, although nothing, of course, is fixed. And certainly class struggle is not fixed. So there's always a pressure to change the constitution. So in some ways, the constitution weighs like I like that word, weighs like a nightmare on the brain of the living. It's a way in which the past perhaps dominates the present. And so in that sense, the constitution has to be seen as a class question and indeed a site of class struggle, except that economism as a trend of thought in the movement, in a sense, bows to the constitution and refuses to take it up as a point of struggle. It's not that interested in it. But in the constitution, we almost have the pure class politics, and interpreted, Mike, in the ways that you said. So, in terms of the series, then, okay, just in terms of series, there's two strands, and I always mention these two things. There's a Republican in this abolition series. There's two strands. There's, if you like, a communist strand that says we want to abolish capitalism, money, prisons, constitutions, borders, nation states. We haven't done all those, but war, etc., all those kind of things, which communists want to get rid of, all of those things. Obviously, that's the aim of communists. But then there's a Republican element, which says, it's a different thing, which says we want to knock down these old things and replace them with a new kind of democracy. So we want to get rid of the standing army, as opposed to abolish all armies, but replace it with a people's militia, citizens' army, or however you want to formulate it. Now, these two apparent things, and a Bill of Rights that you talked about comes into that category. It comes into the Republican category, really. Now, of course, I think what Marx and Engels showed us in all of this, and I'll just come back to Republicans in a minute, but what Marx and Engels showed us, they're not really opposites, that one leads to the other. The relationship is through democracy, through the Republican idea, we get into a situation where communism becomes spreadable, internationalized, and ultimately possible. So there's a kind of Republican road, I would call it, toward these communist aims. Now, I think republicanism, and I'll finish on this point really, but republicanism in England has to be seen as not about the Queen, which everybody wants to talk about all the time. It's a whole array of democratic demands. And it can be under that general heading, which we all have to work out. It could be proportional representation, an English Parliament. It could be the abolition of the Crown, the Lords, the Commons, the Privy Council. It could be having the right of recall. It could be a written constitution. It could be a Bill of Rights, a unicameral Parliament, local democracy, things which you all mentioned. In a way, that is the, if you like, the Republican program. It's a whole range of things. It's not about the Queen. Essentially, it's about this total, one word, if you like, use the word democracy really, but I would say the Republic is one word that around which we can gather forces, because all those things I've listed in there are popular with thousands, not all the same things, by the way, but are popular with millions of people. If you ask people about proportional representation, you would see that's something that millions of people have thought about, because people have got their heads around democracy in some ways better than they have around this idea of communism. So that's meant to be a contribution, but I just go back to where you said, I think what your talk was really good, and I enjoyed it. And I think it is about the Bill of Rights that you talked about and the democracy that you talked about. I think that is, we're talking a republic here, Mike, and you know, that's really what I'm saying, and quite rightly, in my opinion. Okay, thank you. Tony, over to you, Tony.
Thanks, Steve. Right way up at least.
Okay, can you hear me?
Yes.
Right, good. Yes, I would second what Steve says. It was a tour de force by Mike, but I would expect that of an Oxford academic after all. However, I'm not necessarily in total or complete agreement with Mike, notwithstanding his contribution. To start with, the fight for democracy, the fight for democratic rights, for civil liberties, however you describe it, is an essential and integral part of the fight for socialism, because that is what socialism means. It means a fully democratic society, both in the political and the economic sense. However, I think it's, and I also support, therefore, a Bill of Rights, which would affirm those democratic rights. However, I think it's a mistake to counterpose the benefits of a written constitution to an unwritten constitution. I don't see any great advantages of the former over the latter. Why is that so? Because in either case, who is to interpret those constitutions? It is the unelected judiciary. And we've seen in the United States, the Supreme Court is really the Republican Party in not wigs, but certainly gowns. The agenda of the Supreme Court is a right-wing one. We've seen that. Obamacare barely survived. I think it was a one-vote majority when the president, John Roberts, voted with a liberal minority, but that liberal minority has shrunk even further because of Trump's appointments. The right of women, for instance, to control their own bodies is disappearing in the United States, although there hasn't been a firm overturning of Roe versus Wade. I would suggest that's on the cards now, and it's only a matter of time. In other words, when Matthew says that with an unwritten constitution you can pull out all sorts of rabbits from the hat, I would say to him, you can pull an equal number of rabbits, if not more so, out of the hat with a written constitution, because everything depends on the interpretation by judges who are not neutral in class terms, but interpret the law with the perspective of their own class interests and the people who appoint them. And that is as true in the United States as it is in Britain. So although, yes, I certainly support a Bill of Rights, I'm mindful of the fact that judicial interpretation of such a Bill of Rights will whittle it away through time unless they're fiercely resisted. And Matthew gives examples. For example, the president can't declare war in the United States. But as Mike said, the president has declared war because certain clever interpretations of what a war means have been adopted, such that sending troops abroad doesn't necessarily mean you commit them to war. Because as you rightly say, words have meanings which are socially constructed. There is no natural and ordinary meaning. Although in some senses there is a natural and ordinary meaning. It's just that they twist the words out of all proportions in order to give them unnatural meanings. And we've seen this in the Labour Party with the term anti-Semitism. If you ask the man on the Clapham omnibus, or the woman for that matter, what is anti-Semitism, they will tell you, well, it's someone who doesn't like Jews particularly. It might be someone who hates Jews. Who knows? But I mean, that's a general tenor of what they would say. Yet we have the IHRA, which redefines anti-Semitism, not as hatred of Jews, but hatred of Zionism or the Israeli state and what it does. And that really is but one example. We saw the Taft-Vale judgment in 1906, which overturned the Liberals' previous legislation so as to render it null and void. So I really don't think we should go down the road of written versus unwritten constitutions. Just as I don't think we should be obsessed over the form of capitalist or bourgeois government. Yes, for certain, we oppose a hereditary monarchy or a monarchy of any type because it's inherently undemocratic. And it's part of the struggle and the fight for democracy to be rid of a monarchy and have a republic. But to make that the central element of our fight, as Steve would, I think would be a great mistake, I have to say. I will leave it at that. But I may reserve the right to come back at this time. Who knows?
Thanks, Tony. Kevin, do you want to?
Yeah. Thanks, Mike, for an interesting talk. And it's a couple of questions as well as some comments. I wonder if you could comment on the point that Steve has made about economism and about the way that the left, certainly in Britain, has not taken the issue of constitutions and constitutional forms particularly seriously. I'm thinking of, many people's arguments about the Constitution often just amount to comments about the monarchy, about expenses, or the personal behaviour of the monarch, or on some occasions ideas of centralisation of power, so that the real issue of the nature of Crown in Parliament is left to constitutional lawyers and a few academics. It's not really central to a political debate in that way. And I wondered if you could comment on that, because one of the things that strikes me is that in the late 19th and early 20th century, certainly up until the debates around the Parliament Act, the whole peers versus the people question, but also with the extension of the franchise and indeed some forms of republicanism in the late 19th century, it seemed that the Labour movement did take these questions very seriously. And again, I wondered if you'd comment on as to why they've receded. One of the arguments I would make is that as the Labour Party in particular becomes absorbed very clearly into what I think you and other comrades have called the party state. It essentially accepts the parameters of politics. It accepts the only way that you can actually play part of the constitutional game is to, in a sense, to sort of fit into that constitution. So that the state is a party state, that in a sense, the Labour Party is a sort of, well, like a left wing of bourgeois politics. The Tories are the right wing of bourgeois politics. And essentially, they're sort of just fitting into that game. And unlike, say, some European social democratic parties, although the German Social Democratic Party in particular often pulled its punches on the monarchy, the laws were often very restrictive in Germany. And so there had to be some, I think, fuzziness on that. But often many of those parties began as having a very clear Republican and democratic position. And in Britain, I think the absorption of the Labour Party, and probably again from the trade unions as well, have accepted essentially the nature of bourgeois legality. But my main comment is partly in address to Tony, not necessarily about written versus unwritten constitutions, but about the importance of constitutions as summing up in a codified form our conceptions of political democracy and sovereignty. And Mike's point about self-government, I think, is an important one, and particularly the areas that he talks about in terms of universities and local government, and indeed the ideas of managerialism. You're talking here about the nature of power and about the nature of sovereignty. You know, where does power reside? Now, my argument about the relationship between the judicial and the political, between the judicial branch and the executive and the legislative, is that you might, in a series of cases, have interpretations, but that the final rights should lie with the executive and the judicial, with the legislative. In other words, it's a question of democracy, that the people who formulate the laws are the representatives of the citizen. And one of the problems about judicial review, particularly when it's taken up by the left, although it's understandable often as a defensive measure, and indeed, you know, unions may often use judicial review and other legal instruments to try and, you know, protect rights. But what that's doing is, in a sense, subcontracting what are essentially political decisions out to supposedly neutral Augustan figures who, from a great Olympian height, if I'm not mixing my classical metaphors, look down on the case and, you know, pronounce. And they do this as completely disinterested parties. Now, my argument would be that a constitution is about politics, and that the law is about politics. It's about the rights of workers. It's about the rights of citizens. And these are political decisions. And then the point about much of the farming out of political decisions to the judiciary, whether, or indeed any other body, whether it be a European Court of Human Rights or whatever you want to call it, is that those are essentially political decisions, and they should therefore be grounded in popular sovereignty in some form. And I think it's that which your idea of self-government and self-management, the idea of power resting in the citizen, and that in particular that power then has the right to control, or indeed has a right to be free of oppressive powers. Because the point that you made quite well about the Constitution as we have it here is that, in a sense, it arises in a pre-democratic period. It arises from often revolutionary movements, but in comparison, say, with the French and the American constitutions and many others, is that it doesn't have a formal argument about arising from the citizen, about arising from the people. We don't have a declaration of the rights of man and the citizen, because the Constitution, in a sense, arose in a different form. So we're always, as citizens, or indeed as subjects, we're always on the defensive. And I think your argument about self-government and self-management is that we have to take that power, we have to assert that power, and that's really the basis of a constitutional form. Anyway, I'll leave it there and let other comrades come in.
Mike, do you want to come back on that so far?
Yeah, I've come a quick comeback on some of this stuff. Steve, I think that we need not only a minimum program, which is a program of radical democracy, and I am going to say radical democracy rather than republic because of the ambiguity of republic, in the sense that it's widely believed that we should have a republic, we should get rid of the monarchy and have a presidency, which is, hey, it's a different form of monarchism. It's elective monarchism rather than hereditary monarchism. But a radical democratic constitution, and the minimum program, as I understand it, is a program of radical democracy, but also of certain minimum economic demands, like I guess actually the maximum working day and the maximum working life, the compulsory retirement age, both of which the capitalist class has used anti-discrimination as a vehicle to undermine what Marx called the modest Magna Carta of the working man. So there are economic elements as well as, but it's also necessary to have a sense that we can get all the way outside of all this crap, that we can, okay, it's not what we're going to be able to do immediately. To do it is going to involve a substantial period of constructive work as opposed to tearing down work. You know? But nonetheless, we have to actually look outside of and go beyond just tinkering with this system. And it's getting beyond just tinkering, setting ourselves goals which go beyond this system, which enables us not to be dragged in behind, whether it's, say, for example, dragged in behind the Brexiteers or the Remainers, or behind the Scottish independence guys or the Unionists, as the case may be. Tony, the case I have for written constitution is just increased transparency. It doesn't get rid of interpretation problems. Obviously doesn't get rid of interpretation problems, but it's quite clear that it does increase the available transparency. It's also an opportunity to think about what's in the Constitution in a positive way, and to think to draw a line under the old Constitution. Suppose that we were the monarchy fell and Parliament became regarded as totally unserious, that revolution was in the air. The idea that we would want to say, oh, well, let's set up a customary constitution. It'd be a little bit like, I suppose, People's Republic of China under Mao. There was no law. They formally abolished the code. The Chinese, they formally abolished the Chinese civil code and had no laws whatever, and therefore no constitutional law. But of course there were rules. They were just the rules of the Chinese Communist Party were actually the practical constitution of the country. So that I don't think it works to say we just go for, we will abolish this and then we'll create a new customary constitution. That's not doesn't work. It doesn't solve, you can't get rid of the problem of interpretation. You can't get rid of the problem of delegating decisions to smaller groups of people, because that, again, it's the, oh God, I can't remember the woman's name now, tyranny of structurelessness. Something which everybody ought to read. Tyranny of Structuralists in its fundamental text. You can find it on the web all over the place, but it is a fundamental text. You can't get round having procedural rules. You can't get round delegating and decision-making processes where you narrow down and so on and so forth. No, you can't escape that stuff, but we can get more transparency than we have now. Do we care what form capitalist government takes? Well, actually, some of the aspects of the form are forms through which the capitalists govern. The form of the original English constitution as it was a form in which there was a high level of self-government in the localities and in sectors and so on and so forth, coupled with explicit controls on the franchise that you had to own property. And going along with the explicit controls, you had to own property, and going along with that, of course, women were married women were wholly excluded because the law said that their property was all their husband's property. So it's a narrow franchise, and it's also one in which it was completely routine throughout the 18th century and into the early 19th to sell your vote. It was open. You could openly trade your vote for stuff. Okay, that happens in Parliament. I can't, again, the MP for Whitby told us some years back that he sold his vote in exchange for the Humber Bridge. He sold his vote on student loans in exchange for the Humber Bridge. Austin Mitchell to the Treasury. Okay, but you could sell your vote for cash, and then the effect of that is that this is a business. The state is a business corporation, and you get votes in proportion to your shares, because the big guys can buy more votes, and indeed they can buy whole constituencies in the unreformed system. Old Sarum, the old former city of Salisbury, had 2 MPs, and the whole of the borough was owned by a single individual, and a whole load of others, these pocket boroughs of one sort and another. So it's and Edmund Burke, he just said the state is a joint stock. The state is a business corporation. Okay, so now we get rid of that through the Chartists sort of won gradually the vote. We won the vote, but somehow the character of the state as a business corporation, that it's the state for the rich, has to be maintained. And the way in which it's maintained is the combination of the right of MPs to stand over and over again for their seats, 5-year parliaments, single member constituencies, press oligopoly. And then the consequence of press oligopoly is that Conservative Party gets in most years, in most election years, the Conservative Party gets very large amounts of advertising coverage for free in the national daily press. How do you overcome that? You have to seek to advertise. And in order to advertise, you have to sell your operation, as Tony Blair did, on the largest possible scale to Sainsbury and other people who are going to be big financial donors to the Labour Party, in order to be able to counterweight the press by your own advertising. So in essence, this is a regime of corruption. Yeah. And the other element of the regime of corruption, again, going back to, we abolished the fixed limits on fees for lawyers. There were, until the mid-19th century, fixed limits on lawyers' fees. And taking more than the fixed limit was an offence, for which you could go to jail for a year and a day. We abolished those, again, at the time when the franchise is extended. A whole load of things of these happens, one of which is, again, so that we have now in the world, we temporarily abated the problem by having legal aid between 1945 and major administration, but in essence, it's a regime in which justice is sold and denied in violation of Magna Carta Cap 29. So actually, yes, my point is that these institutional forms, they aren't necessarily, these institutional forms are forms of the Constitution. It's part of the constitutional order, which says that this is an oligarchy, a plutocratic oligarchy, through the institutions of the single member constituency, the press oligopoly, the sale and denial of justice through the lawyers and so on and so forth. Kevin, on the Labour Party, I actually think that the Labour Party was always Lib Lab and Fabian from its outset, and yes, the Socialists and the Independent Labour Party were included radical opponents of the Constitution. The Social Democratic Federation and the Independent Labour Party and the various other socialist groups, but quite a lot of the people who were in the early Labour Party also, but the actual MPs in the Labour Party, that was a deal whereby people were given the Labour name but elected with Liberal votes, and it was a deal under which they voted for the British Empire with the Empire Liberals, imperial Liberals in foreign affairs. And the Fabians are very explicitly pro-constitutional party. Is the idea of popular sovereignty absent, again to Kevin, in the history of the English Constitution, is not quite true, because it's there. How shall I put this? It's strongly present in Whig political thought of 1689. The Whig theory of 1689 was that James VII and II having deserted the country, the government was dissolved and power reverted into the hands of the people in the form of the convention, and that the convention then offered the throne to William III on terms and conditions. And that those terms and conditions were then binding on William III and Mary and the successive kings, because the underlying, the convention expressed in some sense popular sovereignty. So what shifted is that in essence, Herbert Butterfield's book, The Whig Interpretation of History, and the canonization of Butterfield's book, The Whig Interpretation of History, has had the result that the politics of the Tory party are taught in the history departments of schools and universities. Because if you don't teach the politics of the Tory party, you're falling into, quote, Whig history, which Herbert Butterfield has shown is a terrible phenomenon, and so on and so forth. And that is a means by which we are taught in schools, just as the guys in the Soviet Union were taught official Marxism in schools. Yeah, we are taught in schools official conservatism under the guise of its being history. That's it.
Helps if I stick my microphone on. Okay, thanks, Mike. Right, well, if Fliff wants to put microphone on and then the camera, I'll speak. Otherwise, Christine. Christine?
Yes, hello. I'm only coming on being a self-effacing older woman because Matthew said, don't just ask a question in chat, put your hand up. So I'm here to represent my demographic again, which is old disabled people. I did wonder how a written constitution would help disabled people. There's a meeting tomorrow, which I'm helping to organise, called Shafted, because that's what's actually happened with disabled people throughout history, and particularly with the present government I don't see any hopes of improvement, but do you think that a written constitution or a Bill of Rights might actually achieve something for us? And I'll put the details of the meeting in the chat, so please do come along, everyone, because you know, the position of disabled people in this country is probably worse than anyone, and the left should be concentrating on that as a great injustice that needs to be righted. And if a written constitution can do that, that would be wonderful, wouldn't it? Thanks.
Thanks, Christine. Cliff? Oh.
Sorry, I'm basically eating my tea, so I was mostly just listening, but I thought I'd upgrade to sort of, in case I wanted to contribute, but so far I am just listening, so.
Okay, you don't have a particular question then?
No.
Okay, all right. We'll go back to Tony then. Tony, you need to unmute yourself.
Okay, I've unmuted, I think. Can you hear me?
Yes, we do.
Right, okay. I mean, all of these things, the fight for democratic rights, the defence of existing rights, the fight for a better society, a socialist society, all of them really depend on the balance of class forces. And there is nothing in a constitution which in itself will guarantee the protection of those rights. For example, I mean, Christine mentioned disability. The defence and the protection and advancement of disability rights really depends on the issue becoming integral to the fight for socialism and for democratic rights. Nothing in a constitution will cement that or defend that. And to suggest that it does, I think is a diversion in many ways. Likewise, I mean, Mike's only real defence of a written as opposed to an unwritten constitution is that it's more transparent, but I would disagree. I mean, most people don't go into law books and investigate what is and isn't in the British Constitution anyway. So, I mean, the transparency, I think, is more an academic point than a real point. But given that the interpretation of a constitution lies with the judiciary, and the whole role of the judiciary is to mystify the actual forces behind the law through clever interpretations of words and phrases in a way that really beggars belief at times. I mean, the fact that workers' rights have been dismantled at the moment, I mean, all protections are lost if an employer just sacks someone and puts them on 0 hours contract, in itself shows that even statute law, which is as good as a constitution, doesn't hold sway. I mean, the judges can't rewrite laws, but they have a jolly good go at it and usually succeed. And I defy Mike to tell me how it is that the US Constitution is any more transparent than the British Constitution, except that we have a nakedly political Supreme Court, all of whose decisions accord with the most right-wing thinking in the United States. So the interpretation of the right to bear arms is really the right to bear arms if you're a right-wing militia. If you're black and you form a militia, that's immediately a threat to the state itself and will accordingly be dealt with. And incidentally, the right to bear arms, I'm very, very dubious about having that written into a constitution, precisely for the reasons that we see in America today, where it's not an advance or a protection of workers' rights or black rights or any other rights. So I guess that, well, the Bill of Rights as well. I mean, I support the Bill of Rights, but it would be a fundamental mistake to see that as any panacea, because again, it will be whittled away through the way it's interpreted. And so all of these things depend on the balance of class forces in society at the end of the day. Thank you.
Thanks, Tony. Steve, you want to say something?
I'll just unmute myself just to come back. Of course, there are no panaceas, and if we're looking for them, then we're not going to find them. That's obvious. I mean, you can discuss a Bill of Rights as a thing in itself. In other words, it's a single issue. The judiciary and everything else, imagine everything else remains the same, and we just have a Bill of Rights. that wouldn't be a big change. It would be a problem. So if we take out one single demand, a Bill of Rights, and discuss it in isolation from the class struggle, then of course it's not a panacea for anything. And it's wrong to say that. But I would say to Christine, just want to answer Christine, we're in a situation where the constitution of this country, I think, is broken. It was called an elected dictatorship, but I think it's slipping towards a dictatorship, and we're in a very dangerous position. But the fight for a Bill of Rights, the fight for rights for disabled people, if disabled people in this country decide we want fundamental basic rights, we want them written into our constitution, that would be quite an important mobilizing thing. Trade unions need basic rights as well. So there's a whole range of things where people can mobilize and see that we need different laws, a different system of laws to the ones that we've got. Now, I was going to say this, that a republic is fundamentally about democracy from below. It's not about royal democracy from below, obviously. And if you use the word radical democracy, Mike, and then somebody says to you, okay, Mike, radical democracy, is that a republic or not? Will we keep the Queen or not? Then you're going to have to answer that question, to be absolutely honest. And I think, therefore, you should face up to that fact. We're talking radical democracy, we're talking a republic, some kind of republic. And I want to then go back to this other point, which Tony possibly hasn't understood. The abolition, republicanism is about democracy, it's not about the Queen. However, the abolition of the Queen, let's imagine we had an abdication crisis, then we'd have, as we had in, let's say, November 1918, when the Kaiser disappeared, or we're giving lots of other examples, we'd have a default republic momentarily, where we would have an intensification of class struggle, because it wouldn't be matter, shall we have a republic? It becomes, what kind of republic will we have? And that's what happened in Russia in 1917. The republic happened in February, then a whole big struggle took out. Well, should it be this group of people? Should it be that group of people? So Tony's idea, the only kind of republic we can possibly have is the American one. And then to tell us how flawed that is, there's many different types of republics, and it will be determined by the class struggle, what kind of republic that we have. So I don't think we should get besotted with America and simply say that's one pretty much, you know, we know what's wrong with America, by the way, so we don't need a critique of that. So I just think that if the monarchy was to go tomorrow, somebody say, oh, well, the only thing we can now have is a president, which, as you say, Mike, is like having an elected king. And it wouldn't be any different, because the people already empowered want to keep everything as much the same as they already had it. They want nothing much to change apart from just one thing. But the rest of society think, well, we would like, perhaps the disabled people would like a Bill of Rights, perhaps we'll need PR, perhaps we'll need this and that. And it becomes a point where everything goes up in the air. And that's the process, I think, that we have to think about. We might think about it as a static thing, but as a dynamic thing that we're looking at. Finish there.
Okay, thanks, Steve. Mike, do you want to make final sum up?
Okay, final comment two final comments. One of which is, oh, sorry.
Yeah, you are unmuted. You
I am unmuted. You can. Sorry, it was just sending me a message saying I hadn't unmuted.
It does that sometimes.
Yeah. Okay. Just on Steve's point, actually, in Germany in 1918, Philipp Scheidemann announced the Republic in a hurry because he'd been told that the left was going to announce a Republic of Workers' Councils if he didn't get in quick and announce a SPD majority government. Friedrich Ebert was utterly pissed off with him. He wanted to have, Ebert was the other right-wing leader of the majority socialists. He wanted to have the monarchy. He wanted to say, okay, we get rid of the Kaiser, but we just get some other relative of the Kaiser to come and be a constitutional monarch. So I don't think doesn't quite work as sort of, okay, we're going to have a crisis will break out. And then as a result of a crisis breaking out, then it's dynamic. Or indeed, we agitate for republic and nothing but a republic. And that just opens up all the doors just open up, etc., etc., etc. We agitate for a democratic republic. That I think that's absolutely correct. I'm not saying we agitate for radical democracy. We can agitate for radical democracy and not talk about the hereditary monarchy or the House of Lords, the appointed House of Lords with a few hereditaries in it. The underlying question, however, is Tony's question, and that is, what is the use of this of agitating around the constitutional stuff? And the answer is, the question is, how do we change the relationship of forces? How do we change the relationship of forces? We need to rebuild the movement in circumstances where the movement has successively become deeply managerialized, and the managerialization of the movement has resulted in its being eviscerated because the loss of initiative in the localities, the inability to organize your own election campaigns on your own political line in constituency Labour parties, the inability to organise your own local strike action as shop stewards organisations or in your local trade union branch, the level of managerialisation and control has resulted in eviscerating the actual organised movement, rendering the organised movement empty. In order to overcome that, we have to spread the idea of the illegitimacy of the present constitutional order, of the illegitimacy of the judicial decision making, of the illegitimacy of the parliamentary regime under which members of parliament get a 5-year term, which they can then turn into directorships and other jobs after they step down. And we need to actually carry on undermining. We can't just undermine capitalism as an economic system without also undermining the means by which the capitalist class as a class rules politically, and by which the state order, which pretends that it's, yes, Olympian characters standing above the fray, in reality serves the capitalist class. So that the point is not that we will kick off, we will cause there to be a republic, we will get a written constitution that will solve all the problems or any of these things like that. At the end of the day, it's about how to pose the possibility that another world is possible, that another social order is possible. I said very much earlier on in the response to Steve's first point, we do also need the maximum program. We need a platform of radical democracy, of democratic republic, if you like, whatever the hell you want to call it. We also need the vision of a society which goes beyond the world of money and endless growth and the British competitiveness and all the other crap. In that context, Christine's point, we have two elements in just on the disability issue. We have two elements in this, one of which is that actually rights for disabled people is for people with disabilities is a part of the socialist project, and one which the right wing don't like, and which because it's redistributive, it's from each according to their ability to each according to their need. That's what at the end of the day that's about. Yeah, and precisely for that reason, Dominic Raab's human rights stuff is contains ferocious polemic against the idea that there could be positive rights, and says, no, it's only negative rights. It's only rights to be free from the operation of the state. And the Human Rights Act, they say, has been terribly misused in order to interfere with government decision making about who gets what. Well, the Human Rights Act, I'm not no fan for the Human Rights Act, but that choice about how do you address the question of rights for people with disabilities, and indeed of a whole raft of other issues of one sort or another, unavoidably does involve rejecting the Conservative Party's conception of what the Constitution should be about, or what rights should be about. That's that two sides of it. It's where are we at? Well, we're in the most god-awful situation at the moment. We're in a dreadful situation, but we can begin from a dreadful situation. We can begin, but in order to begin from a dreadful situation, we need to begin with this idea of how do we reconstruct hope? And that process is going to involve addressing constitutional issues as well as ones which are directly and immediately economic. That's it.
Right, thanks, Mike. And hang on, so yeah, thanks, comrades. I think it's been a very interesting conversation. I had hoped we'd get more contributions, but I think it does begin. Again, we start to ask some really fundamental questions. And I think that's been really the debate about doing these educationals is that we do sort of look at a whole series of these questions, all of which are going to have to be addressed in greater detail. By socialists going forward, and so it's an introduction. So yeah, thanks, comrades, and we'll see you next week.